Let me share this application. All right. Okay, please tell me you see my cover screen.
I can see the cover screen. I don't think you're in slide screen mode yet.
Cover screen.
Okay,
Bookshelf.
let's try that again.
We saw a lot of bookshelves.
Let's try it this way.
Bookshelves.
Yep, good.
We're good to go. Okay, thank you everybody for being here. This is Legal Foundations. The name of my book, by the way, is Legal Strategies for Startup Success. So I use that byline whenever I can. This is session 4 in a series of 12 that we do every month on intellectual property. And it's, I should say intellectual property law to be more accurate. So let's see. Okay, give me a second. Yay. All right, what we're going to talk about today at a high level well, this is super high, are the basic types of intellectual property, some of the correlative state law rights, some of the types of claims we have. It's a hazard. Whenever you talk to me, you're going to hear about tax consequences, especially now after the big, beautiful bill. And also, like I say, some practical guidance. Now, keep in mind, we're talking about intellectual property law. Intellectual property is different than technology. People sometimes get those two terms confused. Not so much talking about the technology, which is really the secret thing that you do, the invention, the device, the process, whatever. We're talking about the legal protections that go around this. And I'm going to go pretty quickly through this because I do have a lot of slides, but I will, and we're going to finish within the hour by 1 p.m. And I will pause on some things that I think are worth maybe pausing on. So first, let's just define what we're going to talk about today. But well, even before I define terms, let me just tell you the types of IP that I want to focus on. Number one, patents. Of course, everybody in the Valley or even outside the Valley, any inventor knows about patents. Pretty much everybody knows about patents. We're going to talk about them, both utility patents, design patents, and provisional patents. And patents are governed exclusively by federal law. We have this thing called preemption that we talked about way back in session 1, if you joined us. We'll talk a little bit about copyrights. That doesn't affect my practice so much. There was a time when it was more prominent, when people were copywriting software, but I don't see that often. Again, governed exclusively by federal law. Trademarks, we will talk a little bit about, again, governed predominantly by federal law, but a lot of states have come up with their own form of trademark, and so state law is a factor. And trade secret law, which does not require a registration or even allow a registration like the previously 3 types of property, but is super, super important to most startup companies. And then finally, similar rights on the under state law. Those are the types of IP we'll cover. So the kind of the one big one is when people talk about patents, they typically mean utility patents. And that is a patent, it's a federal registration. It's required, the filing is required. And that federal filing or federal registration protects the functional aspects of an invention. So think of it that way. It's an invention and you protect it by filing. It gives the inventor exclusive rights to make, use, sell, or import the invention for up to 20 years, provided that you pay your fees. By the way, here's a practice pointer for you. That's one that I see a lot. People forget to pay the fees and they run into problems with their patents, and then it costs a lot of money to fix it. So that's an important little detail there to keep in mind. And the other thing I want to pause on this is when we say it grants the inventor exclusive rights to do these things, keep in mind with IP generally, the concept of a property right in IP is not that you're given the right to do something. It's that you're allowed to prevent everybody else from doing that thing. And that's a concept that it's useful when we think about property to start thinking of it in that way right from the start. And that's true of all kinds of property, but especially in intellectual property. This desk here, let's say I own this desk. Does that, the fact that I own it, does it give me the right to pound on it? Not really. It just gives me the right to keep anybody else from excluding me from using this desk. And it gives me the right to exclude them from using the desk. So think about property rights in that way, especially IP rights. Utility patents cover how an invention works, not its appearance. We'll talk about the appearance in a minute. And here's the big thing that you need to keep in mind. And this is why patent lawyers charge so much money, is because in order to be patented, your invention has to be novel, meaning it's new, has to be useful, and it has to be non-obvious. And there's tons and tons and hundreds of years of litigation over what those terms mean. But that is the essential elements of a utility patent. We also have design patents, which are more popular than you might think. And rather than a functional patent, it grants rights to the design of a manufactured item. And it governs the appearance of the product, its shape, its configuration, decoration, not its functional aspects. And again, you can prevent others from copying, using, or importing a substantially similar design. It lasts 15 years from the date of the grant. And it does require a registration. Doesn't cover how the invention works, only how it looks. Now, patents are very expensive, and a lot of people want to defer that expensive cost of a federal registration. The legal costs are anyway. So you will oftentimes hear people talk about provisional patents, and that's a temporary filing, 12 months, that is made with the U.S. Patent and Trademark Office, and that allows the inventor to secure an early filing date. Because if you get in a war with somebody over patent rights, filing date is essential. We now have, for at least for the last several years, we have a first to file system. So people will want to get that provisional filed as soon as they can, and then they've got 12 months in order to refine and file their non-provisional application. The caveat to this, where people might get in trouble with this, is because they feel like it's a provisional, they don't put the work into, writing a really good patent application, and they run into problems in the next 12 months when they try to file the utility application. With good legal counsel, you should be able to avoid that. And different lawyers have different opinions as to the use of this. I've heard patent lawyers say don't do it. I've heard patent lawyers, I think most patent lawyers I talk to see the value in provisional patent filings. It's lower cost. You can use the patent pending. You got a little bit of flexibility before you do the formal patent. So that is the provisional. Moving along, copyright, like I say, I don't see that in Silicon Valley technology world as much very often anymore. But a copyright, unlike a patent, which covers an invention, a copyright grants the creator of an original work, like a book, or like my slides that I'll be distributing, the exclusive rights to copy, distribute, display, and or like a play, a movie, or perform that work. Applies to literary, artistic, musical, or other creative works, not the ideas, right? So, and we're going to talk about that when I get to the artificial intelligence section of this. The ideas themselves are not protected. It's only the tangible expression. It lasts for the creator's lifetime plus 70 years. So you give the estate some time to make some money off it. And here's how another thing where copyright differs from patent. Registration is not required for copyright protection, but it does help in legal disputes. Okay, you want to register before you sue somebody on a copyright. The holder of a copyright has a right to reproduce the work, to make copies of it, to make derivative works, right? So you can make a movie based on a book if you own the copyright to the book or the screenplay. You can distribute the copies to the public, perform the work publicly, display the work publicly, for example, in a Zoom call. Let's suppose somebody infringes a copyright. The damages is, we'll call it plaintiff oriented. The copyright owner gets their actual damages from the infringement, plus disgorgement of profits by the infringer. Now, remember what I said, it helps to register. You don't have to, but if you do register, you also can get statutory damages which can be anywhere from $200 to $30,000, and even more if it's willful infringement per violation. It's the court has a lot of discretion on that, but also attorney's fees, which could be a big deal in an infringement lawsuit. So usually if somebody really is wanting to protect a copyright, I'll say go ahead and register. It's worth it if you think people are gonna try to mess with your copyrights. Moving along, trademark. This differs than the other types of IP that we've talked about, and that a trademark is a legally recognized sign, word, phrase, symbol, or design that identifies a company's goods. So the idea of a trademark is just to distinguish it and identify it in the marketplace and distinguish it from other goods. It helps the consumers recognize a brand, so it's very much tied in with branding and logos, right? And you also have the right to prevent competitors from copying your mark and trying to create some confusion, as I have heard sometimes happens. Protects slogans, product names. Again, it can be registered with the U.S. Patent and Trademark Office for stronger legal protection. Here's something kind of interesting. You'll see these marks TM and R. So TM just means you have the trademark. That's for an unregistered trademark. You can use that. The little R in the circle, you only use that if you've registered the trademark. So be careful about that so that you're not saying something deceptive. The trademark, unlike these other types of protections that I've talked about, can last indefinitely as long as you're actively using the mark, but it can also be abandoned. It can be lost, it can be lost anytime too through an abandonment or non-use. Now, remember I talked a little bit about design patents, right? But a trademark is different. The design patent is the ornamental design of a product, right? The trademark is really the logo or whatever, the distinguishing mark that distinguishes you from other products in the marketplace. Design patents and a trademark are two different things. Plus, the design patent is subject to all these rules about patents, registration, they're limited in time, etc. Whereas a trademark, again, is not subject to those rules. I think the design patent is probably closer to trade dress than trademark, but keep in mind there is a distinction. Now, let's pause a little bit on the practical aspects of this. Now, I've given you the three major types of federal registrations. And I will tell you, trademark might be your most valuable asset. And I want you to think about this for a minute and just think about what would happen to your company if one day you got a cease and desist letter and somebody said, you can no longer use that name. You have to stop now, or you have to pay us a license fee, or you can't use that mark or that logo. And companies oftentimes will spend many, many years just building up a lot of value around their name and not thinking at the outset just how closely associated the goodwill, meaning the expectation that customers are going to return to their business, is tied into that mark and logo that they use. So trademark can be a super valuable asset, especially if you're B2C, right? I mean, just an example I like to use is Snapchat. I mean, but you could use any of them: Snapchat, TikTok, Facebook, Instagram. What would they be if tomorrow they had to change their name? I would use Twitter, but Twitter did change their name and they didn't seem to go away at all, although I still think of them as Twitter. But just keep in mind, it can be a super valuable asset. That being the case, once you start off, the first thing you should do as a startup founder is just do a search. Do a search online and research existing names and logos, because don't even start using a name that's confusingly similar to somebody else's, especially if they're in a related or similar business as yours. And I tell the story often about companies that I've represented that go out to get acquired. And as soon as we announce, we start getting these letters saying, hey, you've been infringing on my trademark, and I want, you have to stop your deal or pay me a license fee. And then finally, I do a whole presentation on branding. And like I say, trademark and branding is very closely related. So just keep in mind that you want to brand your company, not only legally, get a trademark that's very strong, and it has all the good elements of a trademark, but also is strategic. And what I mean by that is how is that going to position you in the marketplace? So trademark infringement, we have this concept of infringement, and that really is broader than what you might think. So reproduction, certainly, imitations, but also any sort of imitation of a mark that's likely to cause confusion, mistake, or deception. And that concept, a likelihood of confusion, is based on the perception of the consuming public. Let me give you an example. I used to be a partner in a law firm many years ago, more than 20. I don't want to say the name, but they had a name that they had used for many, many years, and it had 3 words in that name, and it didn't have any of the names of our partners. It was just sort of more of a, just a made up, name that you would get the idea that we were a law firm, but that's about it. One day I got an email from somebody asking about a case that we were handling and etc. Well, he sent it to the wrong firm because he meant to send it to another law firm that had 2 of the same 3 words, but not the 3rd word. And then we got in a big fight over who, whether that other law firm had infringed our name. Was that confusingly similar? Seemed to me it was. It did, in fact, confuse someone in the public. So that's really the standard, is likelihood of confusion. Now, some of the defenses here, no likelihood of confusion, it's not descriptive, or there's no secondary meaning, it's generic. Now, if there is trademark infringement, and by the way, when you do choose a strong mark, I probably should have said this, think of the strongest marks you can think of. They are not descriptive, right? They're not going to develop this secondary meaning. They're not going to become, aspirin that, or something that you think of that applies to everything in the market. They're words that are sort of nonsensical. Google, Exxon, Xerox, strong trademarks really are very, very distinctive in that way and not descriptive. They're not words. They're not even foreign words, right? So if I have a company that sells cheese, I can't call it the fromage company. It would not be a good mark, right? Hey, for Bob, that fromage is cheese in French, in case you were wondering. All right, remedies for, nobody likes my joke. Okay, remedies for if I can't pick on Bob, then I don't know why I have him here.
I didn't want to say anything. I was trying to be quiet.
So remedies, if somebody does infringe on your mark, you can get injunction. That means you can get a court to order them to cut it out. But you could also get monetary damages, which include the lost profits that you have because they've used their mark to take away your business. And sometimes you can get attorney's fees in exceptional cases. Now, something closely related to this is trade dress infringement. And that protects the look and feel. That's how we call it in the Valley OA, is look and feel. And what we mean is the visual appearance of a product or the packaging. So, think of the Coca-Cola design of the bottle, right? Think of the way that McDonald's is laid out. Think of a distinctive color scheme. And we see those sorts of claims sometimes. Infringement for a non-functional trade dress. You're just copying our look and feel. Now, that's it with the federal registrations. I want to talk about some related federal rights that have arisen over the years that are very similar. Cyber squatting. And this is the idea that you sit on somebody's domain name and then try to sell it to them, in effect. In other words, you register an internet domain name with the intent to profit from the goodwill of a trademark that belongs to someone else, right? So if somebody goes out and, registers rogerroyce.com and then sends me a letter and says, hey, you can't use this name because I got it, unless you pay me, we might have a problem. There's similar to that. There's this thing called typo squatting. You get a domain name where maybe they'll use an S instead of a C in my name and still try to hold me hostage for ransom. Impersonation, you use a misleading domain to mimic a legitimate website. Yeah, don't do any of this stuff. Don't do any of this stuff is my advice. because we have legal protections against that under federal law, as well as under the registering agencies, which are listed here. By the way, technically, just to pause on this for a second, because everybody kind of thinks of it this way, there's really two things going on. One, there's the trademark itself, and secondly, there's a domain name, two completely different things. So one person can have the trademark, another person can own a domain name. There's still no harm or foul. It's just when that person who owns a domain name acts in bad faith with it that we start running into problems. Now, going back to the practical pointers, what people always ask me, they say, well, what does all this stuff mean for me in my website, right? Because, you know, I've got Skittles.com websites. All I do is I resell Skittles or whatever it is. Okay, so here's kind of the analysis that we go through when we look at a website, at least on the IP side. Number one, copyright. Please have all original content. All right, original images or images that you have rights to. You know, you can buy them from, I don't know, Shutterstock or somebody. Make sure you have the rights. Have the rights to the videos. Have the right to all of the code, so you don't get in trouble over copyright. You do not want to go cut and paste somebody else's website and then, you know, paste it onto your own page. That is a potential copyright violation. You know, it's years ago, I had an intern, a law school intern. I asked him to put together a deck for me on intellectual property law. And so he put together a deck and he had a beautiful graphic on the front, on the cover. And I had to ask, I said, do you mind if I ask where you got that beautiful graphic? Oh, I just went on this website and copied it. It's like, yeah, you know, it's not a good look, you know, to when your deck on IP law actually infringes on somebody's copyrights. So we're not going to do that. Copyright actually is a trademark and as a copyright infringement. Next is trademark. You're going to have a name again, you know. We have to worry about trademark because that's where you're going to display the mark. So you're going to protect your mark and you're not going to infringe on anybody else's. Patent, you could have patent implications. If the website incorporates some unique technological innovation, and that happens very often, that we'll have something that's patentable that's used in the website. Trade secret, if you've got some interactive website or it's got some functionality that uses algorithms or it accesses a database of any sort, there's likely trade secret involved. And then finally, the big one that we find in addition to terms of use, but the big one is privacy and data protection. And I've got slides on that coming up, but just understand that there are several regulations that are going to govern privacy and data protection if you're interacting at all. If it's more than just a splash page and you're gathering any identifiable information of the people interacting with the website. Okay, now let's talk about trade secret. And we've talked about this a couple times already because this is probably your most valuable asset. I said trademark is a valuable asset. This is likely your most valuable asset. And trade secret, you can, well, let me just give you the definition. First of all, it's any information that is, number one, secret, okay? Once it's out there in the ether, in the public, you know, it can't be a trade secret because everybody knows about it. So that could be a formula, a program, a device, a method, a technique, just the way you do stuff if it's secret. And it has value. And that value derives from not being generally known. Okay. And then third, and this is the big one, and this is the one that makes this particular IP so fragile. It has to be the subject of reasonable efforts to maintain its secrecy. So that's where people screw up. That's where people mess up. You have to put in place some sort of efforts to keep that secret. So, for example, you might have your secret process as to how you do your software program, for example, but you have to have something in place so that other people don't see how that process works. Well, what are those reasonable steps? Number one, first and foremost, it's so easy. Nobody should not do this. Non-disclosure agreements, right? Anybody who sees any part of it should sign a non-disclosure agreement. And CIA, meaning a confidential information agreement. They promise they are not going to disclose it to the public. Secondly, if you have a lot of people internally who are going to have access to this, you should have training so they understand that they need to keep this stuff secret. And I would say that training extends to cybersecurity because you don't want somebody hacking into your system, stealing the secret, putting it out there. If you have a court say, you know, you didn't take reasonable steps to stop that, you may be in trouble. You may lose your trade secret protection, even though it was wrongfully obtained. I like to see a good set of trade secret policies for larger organizations. And again, as I said, we want to have good security so it doesn't get out there. Now, let me give you the example. During COVID, everybody went to Zoom for their meetings. And there was a company quite famously that they had a big Zoom meeting and they put up their deck and they disclosed some trade secret information. One of their competitors just happened to log in and participate in the meeting. He saw this, basically started using it, sort of like, oh, so that's how you do it. And in the ensuing litigation, the company, the owner of the trade secret, lost that case. The court said, you lost your trade secret protection by putting it on Zoom and not restricting who could log into that Zoom account. You did not take reasonable steps to protect it. So that tells you just how fragile this particular asset could be, even though it is super valuable. And we now have a federal law of trade secrets. Well, now, since 2016, Bob was even young back in 2016 when this was enacted. We have the Defend Trade Secrets Act of 2016, and it allows companies. So now you can sue these trade secret lawsuits can be sued in federal court, and the courts have expanded opportunities to enforce this. They can order the seizure of trade secrets. The idea is to have a consistent legal framework, but we still have state law. So we've got both state law of trade secret and we've got federal law. And which one you want to proceed under, I guess, depends where you are. The big thing to note about the federal law, you can get your attorney's fees in these lawsuits, provided that you warn people about their whistleblower immunity, which means that if an employee discloses a trade secret in reporting illegal activity, that's basically a carve out from the Defend Trade Secrets Act of 2016. We talked about this already, types of trade secret, product information, processes, specs. You know, a customer list can be trade secret because I see salespeople, they move from company to company and they take their Rolodex with them. Well, big question, who did that Rolodex belong to? Because if it's got customer specs and phone numbers and addresses and the contact person, kind of meets all my requirements, doesn't it? Right? It's secret, it's valuable, you're protecting it. So that's something we fight over oftentimes. And that's a non-technical trade secret. These days, data is oftentimes argued about under trade secret law. Now, I know what you're all thinking. You're saying, what's the difference between that and a patent? And you might even think about, sometimes people think about an invention going from trade secret to patent. It basically graduates. I don't really think of it that way. I think patents do start off as trade secrets probably, but they're very distinct sorts of protection, and they apply to different types of information for the properly advised. Now, sometimes you do not want to patent your trade secret, even though it is patentable. Sometimes there's an advantage to keeping it as a trade secret. And when is that true? Well, let's talk about the advantages. We don't have all these requirements. Remember the non-obvious requirement in order. So your trade secret could be non-patentable. It could be you just don't meet the standards for patenting the invention, but you can still protect it under trade secret law. Right. So right. So that's an advantage. No government filing required for trade secret. You don't have to make these public disclosures of all this trade secret information. So that's useful. And a trade secret can involve, unlike a patent filing. So that's another useful aspect of this. The other thing is that trade secrets last forever. Patents only 20 years. So keep that in mind. And there are companies that rely heavily on trade secret information for that reason, that if they relied on patent, they'd probably be out of business now because everybody would know what they're doing. You can design around a patent, but a trade secret can extend to improvements that derive from a trade secret, and cost is a major factor. Patents are super expensive for a startup company. Trade secrets don't require that filing. And patents can also be uncertainty. You don't know if you're going to get it just because you make the filing. There are some disadvantages to trade secret and advantages to patents. So trade secrets can be reverse engineered. All right. You can't the patent is disclosed. So if somebody reverse engineers your trade secret, you've lost your trade secret protection. But see, patents, you're just disclosing everybody to everyone, and you're relying on the federal court system to enforce your rights. And again, as we mentioned, if you inadvertently disclose through no wrongful acts the trade secret, it loses its trade secret protection. Okay, let's talk about some related claims, IP claims, because we're going to kind of dig into the stuff you might not be thinking of, but maybe should. Especially here in California, we hear about this concept of unfair competition quite a lot. There is a law of unfair competition, the Lanham Act, and both state law as well. They cover that, and that would include things like false advertising, and when somebody infringes an unregistered trademark, or they use some false designation, you'll oftentimes see a claim of unfair competition under the Lanham Act or state law thrown in to those cases. There's also this concept under state law of misappropriation of ideas. Misappropriation, you're stealing somebody's idea. You'll see that claim, but they have to have protectable property rights in the idea, which can arise from contract, right? We've got an NDA that says it's mine, or it's a trade secret under the rules I discussed, or maybe they've got copyright rights. So keep in mind, those are two related claims. I'll give you a couple of others. Invasion of privacy. It's interesting here in California, our Constitution protects individuals from privacy. We have a constitutional right to privacy here in California, and extends both to government and to private entities. And you see it pop up in litigation from time to time. It's not exactly IP, but it's sort of similar. And the more common one is our right to publicity laws, mostly because of our large motion picture industry. We have a quite well-developed laws about publicity. Who gets to use somebody, who has the right to publicize somebody's name. Because notice that when I promoted this event, of course, I used Bob Carr's name all over the place. That's how I promoted it. That's why I got so many people here. I did not use Taylor Swift's name, because she probably would not have let me do that. And she has the right to do that, not me. Defamation and trade libel is exactly what it sounds like. You're saying something that's untrue about somebody, about their product. Unauthorized use of name, we talked about that. And then some business torts, interference with contractual relations, a little beyond the scope here, because once you start going down this rat hole of sort of related to IP, could go on forever. I want to go back to some of the federal aspects of this. You should know about the Federal Trade Commission because they enforce a lot of the laws related to IP protection. Generally, they handle consumer protection and antitrust. And honestly, I don't know where they are these days. We've had a change in administration. Our prior FTC commissioner was very activist in terms of antitrust for sure, and also consumer protection. I think we're a little less activist these days, but nevertheless, the FTC, its job is to prevent deceptive, unfair, and anti-competitive business practices. So it'll investigate fraud or false advertising. It will enforce rules on data privacy, and also will help consumers and businesses. Now, I mention this because there is a very large company that was gathering medical data online, which recently went bankrupt. And that company had a ton of this data online, and they had a data breach. And this happened, not just this company, but a lot of companies. That's happened to a lot of companies. They have a data breach. And whenever that happens, okay, so now that information's out there, and you're probably worried about, oh, gee, there goes my valuable asset. The other thing you should worry about is you know what? We might have engaged in a violation of data privacy rules, and the FTC might come knocking and might fine us. And that has happened. And that actually happens fairly regularly. So they're all over these data breaches under those rules. Okay, now, hang on to your hats. We're going to get into a couple of tax issues about this. It is just one of the hazards of talking with me. So number one, whenever we talk about IP, we've talked about the protections. Let's talk about the economics. So when we have a sale of generally in the law, generally in tax law, we want to minimize tax, and we want to do it by relying on our capital gains rates, right? Because as you probably know, the sale of property, if it qualifies as a capital gain from the sale of property, if it is a capital gain, we get a lower tax rates, 20% federal. California doesn't give you any break at all, but federally it's 20% instead of the potential 37%. So it's important to qualify. When it comes to intellectual property and sales of IP, we have to have a sale of what they call all substantial rights. And we have tons of litigation over what that means. And then there are other requirements, the biggest one being the holding requirement. So to be a capital asset, it has to be held for a year. And then there are a bunch of special code provisions relating to specific times of IP. Now, if we don't have a transfer of all substantial rights, what we have is not a sale for capital gains purposes. We have a license for tax. And that means that the income from that transaction is going to be ordinary income. Now, the flip side is that the person who bought it, the licensee in this case, they're going to get a tax deduction for the amounts that they paid, but the person who sold it, they're going to pay tax at this higher rate. So what does that mean? All substantial rights. Like I say, we've got a ton of litigation over this, but it means pretty much, what you might expect. It's most of the value in that property. So if you limit a patent geographically, usually that means that you're not getting all substantial rights. If you're limited it by time, okay, I'm going to transfer to you the patent, but only for the next year. Maybe not all substantial rights, right? Because patents last a lot longer than that. If it's for the next 20 years, then okay, you're good. If you limit it to fields of use or different specific trades or business, and I won't go through all these in detail because this is an intensely factual analysis. And I will tell you, from having fought this battle for 40 years, the cases are a little bit all over the place, although we kind of know it when we see it. Now, similar to that, suppose you're just forming a company and you've got intellectual property you're going to contribute to the company. Well, you got the same issue because you don't want to get taxed on that transaction. And we learned 2 sessions ago that if you as founder, if you contribute property in exchange for stock in a new company, not a problem. You don't have to pay tax. You qualify potentially under Section 351 of the code, and you got your founder stock and you don't pay tax. Well, that requires property. In order to be property, it has to be all substantial rights. And this is where we get into these case laws that, give you plenty of room to argue with the IRS, or it would if we in fact had a functional IRS, but it's not clear that we do right now. Copyright, taxation. I'm going to go through these fairly quickly, but I just want to give you a sense as to what's the word? The vagaries of the tax law as it relates to IP. Most copyright costs have to be capitalized, right? So somebody incurs costs developing, whatever their copyrighted material is. Most of that has to be capitalized. You don't get a current deduction. Capitalized means it goes on your books and then it gets amortized over a period of time. That's the expense side of creating your copyright. On the revenue side, if you sell a copyrighted item or sell a copyright, you might think you get capital gain if you've held it for a year and met all the requirements. And that's generally true, but there are some real exceptions for copyright. The big one is a copyright held by a person whose personal efforts created the copyright. Okay, so I write a book and then I sell the book. right? Well, my personal efforts created that. So now I'm in this exception to capital gain treatment. And where it becomes an issue is, what if you got a corporation that created the book and then sold the book? Is that personal efforts? And there are cases that put a little more definition around that. Trademark, again, expenses to develop the trademark have to be capitalized. You don't get an immediate deduction, it get capitalized, and then they get amortized over 15 years if it's an acquired, but there's no depreciable life for a trademark if it's not acquired, if you just build it yourself. So that's a problem. It means you get no deduction at all. It just reduces your gain when you sell it. On the sell side, the disposition, we have a special statute to resolve a lot of this license versus sale issues that provide for the treatment of income on a disposition of a trademark and treat it as ordinary if it fails these 1253 tests. So it's a little bit difficult sometimes to get capital gains treatment on sale of a trademark, but not impossible if it is a sale of all substantial rights to the trademark and there's no retention of any significant power and it doesn't look very license-like, meaning that it gets paid out based on future revenues. Patents. This is where I want to pause because this has kind of been in the news lately. So patents are created through research and development, right? Those expenses, there was a time when they were deductible. Then there was a time when they weren't. They had to be capitalized and then amortized. And if they were domestic expenses, you hired people here in the good old USA, you got to amortize it over the next 5 years. But if they're foreign expenses, you had to amortize it over 15 years. So, right. So I pay, $150 to create my patent. That means I get $30 a year deduction if I paid it here. I get $10 a year deduction if I paid it to somebody in a foreign country. Well, our big, beautiful bill, which was just enacted recently, and I have to admit, it's been too recent, and I have not yet undergone the brain damage required to read the full 700 pages. So I'm going to give you the highlights. Plus, I kind of take the what's his name, Scott Adams, the Dilbert creators approach on this is that it's going to be a while before we all know what's in it and what it all did. But at a high level, this is the first place I'm going to mention it. He made a humongous change for Silicon Valley in this area because now these R&D expenses are eligible for an immediate deduction. And up until 2025, up till this big, beautiful bill, they had to be amortized and amortized. It had to be capitalized and amortized. And this is something Silicon Valley has been lobbying for since 2017. So now we got it. On the sell side, I think we talked about that. I want to mention capital gains. There is a special exemption for inventors that Congress created many years ago that says, look, Mr. Inventor, you don't have to hold this thing for a year to sell it and get capital gains. You can hold it for a day. You get immediate capital gains treatment as long as you own a patent before it was reduced to practice. And there's been lots and lots of planning around 1235 and trying to get this immediate capital gains for people inventors that create patents and then sell them immediately. Software, capitalized, depreciate it. What I want to mention about software is that oftentimes there's a time when we protected software under copyright, and that just sort of evolved over the years where I think most of the time we're trying not to do that as a tax matter, well, as a legal matter, because patent is stronger protection, but also as a tax matter. Because as you can see, copyrights don't seem to be very favored. I create a copyright and sell it, I get ordinary income. I create a patent and sell it, I get capital gains. So there's lots of good reasons to protect copyright, both for legal purposes and tax purposes under patent law as opposed to copyright law. And that's how I most commonly see it done these days, if at all, if there's a federal registration at all. I'll just mention that the tax law imposes, all sorts of higher rates of tax on companies that create IP and then sell them, and that's all. So something to be aware of. That's why our IP companies will typically be in a pass-through and not in a corporation. You know, I do want to touch base on the international tax issues on this, because when we talk about, and I'm going to do this quickly, because I'm sensitive to the time. But, you know, my entire career has been a big part of it, planning for the taxation of intellectual property under our international rules. And the reason why is because we call that mobile income. Really easy to move that kind of income. Pretty hard to move real estate, right? Pretty hard to move a house to Cayman Islands. Pretty easy to move IP to someplace like that. And because of that, there are tax abuses and tax opportunities. So here's the typical structure we used to see here in Silicon Valley and every place else for that matter. This is the simplified version. We'd have our US company. They would have 100% subsidiary in Cayman or BVI or someplace. And I've done this 100 times. And we would have our intellectual property sitting in that tax haven. And then we would contract in China probably or someplace else to manufacture, maybe India. And we would rely on various exemptions from our anti-deferral rules to keep that income from being taxed in the US. And you might remember about 10 years ago, it was all over the papers because some of the largest companies in Silicon Valley had this idea of stateless income that they were paying tax to no jurisdiction on. And you might recall even John McCain made a big part of his presidential campaign is getting rid of this huge stateless income idea. It has been diminished significantly, I'd say, under current law. I'm going to tell you why in a minute, but that is the former structure. Here's another variation of it. Again, the concept here is that we're just parking income in some tax haven. And it's mobile income from intellectual property. And that could be license, or it could be that we use the IP to produce products. Very difficult for a startup to do that anymore. And the reason why is because in 2017, we got this thing called GILTI, the Global Intangible Low Taxed Income, which has been changed by the big beautiful bill to a new definition and expanded. But the idea is that income of that controlled foreign corporation is going to get taxed back to the owner. Okay, so that's the general idea. It's an anti-deferral rule, and it has really pretty much shut this entire planning strategy down for most startups. Bigger companies, that have more flexibility in how they organize their affairs, might be able to squeeze a few nickels out of this. But for most startups, it's not worth even talking about putting IP offshore for tax purposes. We just don't do it anymore. And there was a time when I did it every time. So that's the big change. So I know you hate to leave tax, but I do want to cover a couple of other things. I want to mention data, which is somewhat related to intellectual property. Of course, every company now, it seems, has to worry about data privacy laws. We've known about the GDPR in the EU forever, and anyone who's ever been to California knows about our California Consumer Privacy Act, which is going to affect almost every company that does business here. I know there are minimum standards, but they're low hurdles for when you have something like the internet to reach out to millions of consumers. And so everybody really needs to be concerned just generally about those two rules if you're doing business here or in Europe. In addition, there are data protection laws that are very specific to certain industries. HIPAA for medical data, as you all know, and FTC regulations, which we covered, but also Gramm-Leach-Bliley, which has been around forever, probably, well, I don't know if it's long as HIPAA, for financial institutions, which we worry about, especially my venture fund clients, because they have an obligation to protect financial data. And of course, here in California, another example is our Children's Online Privacy Protection Act, which obligates companies doing business here to protect children's data. So the moral of the story here is that we've got both federal law in certain industries, we've got state law depending on who the data belongs to. And we've also got laws in that are very sector specific. Speaking of sector specific laws, artificial intelligence. So generally, this is an old slide because we talk about this in the context of copyright, and I think that's generally true still. That and the issue that comes up is the liability that exists if the artificial intelligence infringes on copyrighted material. Now, there was some recent cases, there's been at least one recent case that I saw where basically the court says, look, a copyright requires human authorship. You know, that's what you have to get copyright. But on the infringement side, the AI is just the same as a person, and the AI can rely on the same fair use. So for example, if a person can go read a book and learn something from that book and that informs them, like my whole slideshow, I didn't just make that up. It didn't just come popping into my head, you know, it was from years and years and years of study and reading statutes cases and other secondary material. Right. So I'm pretty confident I have not infringed any copyrights in putting these slides together. Well, if I haven't infringed according to the court, then the AI hasn't infringed if it does the same thing. So, you know, we'll see how this shakes out in the court system. One of the recent developments here is now, do I have a slide on it? Yeah, there it is. Again, well, let me back up. There was a proposal in the big beautiful bill. There was a Senate proposal to provide a federal preemption of state laws when it comes to artificial intelligence. I think Ted Cruz might have been one of the main proponents of that proposal. And the idea was, look, we can't, you know, we want to advance the artificial intelligence industry. It's hard to do that when you got 50 different states with 50 different rules, plus all the localities. And I think the nation stood up and took notice when California last year had a proposed law that that Gavin Newsom did not sign, that would have imposed liability on the creators of AI for damages arising out of that AI. So there was a federal preemption idea that did not make it into the final bill. So where does that leave us? It means that we can have federal and state regulation of AI. And as of today, 45 states are looking at nearly 700 artificial intelligence related bills. And according to about an hour ago when I last checked, about 1 in 5 of those have become law. So there is a lot of state law in this area. And California, Scott Wiener has recently introduced a new AI bill in California that I'm sure you're going to hear a lot about. There's going to be a lot of debate about it. Again, it's a bill that imposes additional restrictions and responsibilities on the developers of AI. Now, what California does have, just as an example, we have this concept. So California, it's illegal to create and distribute deepfake images that cause emotional distress. That's one. Social media platforms have to implement systems to identify and remove AI-generated deepfakes. In California, because we have a big movie industry, actors have legal protections that require permission before AI replicas of their likeness can be created. We have election-related AI laws. Election-related AI content has to be labeled, and there's a law prohibiting in California deceptive AI-generated political content. And finally, AI-generated content has to be marked or watermarked to ensure transparency. But stay tuned. This is an evolving area of the law, just as it is an evolving technology. You're going to hear a lot more about this. And, you know, we'll see. We'll see what happens. I just expect we'll get federal preemption at some point, given what's going on across the states. And then finally on AI, even though the bill did not have federal preemption, the current administration has done a lot on AI. It's been very it's pro-crypto. It's also pro-AI. So it revoked, there was several Biden era regulations around AI that were mostly restrictive and regulatory. Those have been revoked. But now we have federal rules that instead prohibit foreign influence on AI projects that are connected to federal funding. And they, like, as it says here, impose significant due diligence and compliance companies in that sector. So, but we're seeing federal agencies that are directed to accelerate AI adoption. And so it's a much different environment than what we had even a year ago on AI and how it gets developed. So stay tuned is all I can say. But we're in an environment that I think we're going to see a lot of development. And I don't have to tell anybody here that we are in a race with another large foreign power when it comes to AI. And this is the federal government's approach to help the United States win that race. What do you know? I've made it almost on time. My name is Roger Royce. I'm a partner with Haynes Boone in Palo Alto, California. I do emerging growth and venture capital. That's a picture of me from, I think, when I was in junior high school. So you know what I look like. And there's my contact information. I'm the author of Dead on Arrival, how to avoid illegal mistakes that could kill your startup. And the other book, 10,000 Startups, Legal Strategies for Startup Success. I want to thank you all for being here, and I will distribute a copy of the slides to anybody who wants it and a copy of the recording. So with that, hey, Bob, thanks for helping organize this. Thanks, Don. And we'll see you all in 1 month. Our next topic, I should announce, is going to be on contracts. You might not think we could do a whole hour on contracts, but oh, believe you me, we can. It's an hour on contracts.
Thank you, Rob.